This change in roles, did they bring any kind of creative angle in your dimension to decide on legal stuff or taking a legal decision or judgment?
At the start of it, it was more of a technical thing. Then it was more of a strategic shift. It gives you a perspective while negotiation what to really fight for and what to let go.
How do you think your biggest misconceptions got corrected, especially in the segments of disputes revolving around content creation?
So earlier the idea was that if you have all the necessary clauses in the agreement, then there is not going to be any dispute. But that is not the reality.
Do you bring strategies or you confirm the strategies that the commercial team is putting in, or you both end up finding out some third strategy?
The commercial teams always involve the legal teams at the later part, just for the purpose of contracting, which should not be the case actually.
What is it that we should be mindful about now with the AI usage?
So adopting AI now is
Hello, everyone. Welcome to the new episode of Due Diligence with Rahul, where we do a deep dive conversations with world leaders from legal industry. Today we have Mr. Prashant Ramdas, who is legal head and vice president of a world-renowned channel in radio industry called Radio Mirchi. Welcome, Prashantji.
thank you. Thanks, Rahul.
So, Prashantji, this is a brand new episode of Due Diligence with Rahul, where we want to understand from your side your journey as to how you've become the legal head and vice president of a world famous radio channel, Radio Mirchi. And before that, you've been through multiple roles and responsibilities from media and entertainment industries, various companies. So I would want you to take us through your journey in a brief, right from your education till the current role that you are having and you're discharging your duties for radio channel.
Firstly, I'd like to thank this legal and yourself, of course, for having me on the friendly conversation.
Yes.
Uh, it's been quite ironical. I've spent around 20 years in media industry, but it's the first time I'm coming in front of the camera. I've been always working behind the camera, and it's a good opportunity for me to converse and express my views about the thing. But I just would like to clarify that whatever I speak here, it's strictly my own personal views and does not represent my sector or my organization or the brand which I represent.
Yes. We have taken due note of this and we'll be also putting a very clear disclaimer on this. So please continue.
So to start with, I'm a commerce graduate. I then did my BCom. And when I was doing my BCom, I realized that I was not very good with numbers. I was more interested on the law subjects which were there in the commerce side. So I also had the inclination toward doing something professional, which I can in a long term do on my own.
Okay.
So I was inclined towards doing law. So when I completed my BCom, I did a job and I realized that I was not made. I had to do something professional. So then I gave it a shot. I enrolled for a law course, and then I found it quite interesting.
Which college, Prashantji?
I did it from Bedekar Law College, Thane, which
Okay.
was an evening college.
Okay.
That time I was working, so I had to support my education with the income.
Wow.
There was not much financial backing, so I had to do a part-time thing. I was looking for an evening college, and there was a good option. I used to stay in Mulund, so it was in Thane. So it helped me to balance both, to attend the to work as well as attend the evening college, and I wanted to have the attendance also to attend the lectures. So it quite kind of helped me. So after completing my law from Medical College, simultaneously I used to work with a criminal lawyer from Thane Court and subsequently with a civil lawyer. I personally believe that it's very important, uh, no matter what your aspirations are in legal field, to first have a litigation experience. Because personally, I feel that's the base of a legal career. You know how things pan out in court, and even though if you're interested in non-litigation, it kind of creates a base for you. You know how judges react to a contract, what things are looked into, and it gradually helps in your non-litigation part
Absolutely.
of it.
Absolutely.
I was quite an introvert person. I was not a wit speaker. So I was very clear that I'm not going to be a great advocate or a counsel. But I had a flair for drafting. I love drafting pleadings and creating a case which can sustain the appeals and to the higher courts. So I was more on the drafting side of it. My senior also encouraged me to uh, be good at the drafting part of it. So I continued with my practice for a couple of years. Then
This was in Thane Court.
in Thane Court, yeah.
Okay.
And the advantage of Thane Court was that there are a lot of what you can say forums there. Like there are district court, criminal court, civil courts, consumer courts in the same complex. So you get a lot of exposure there. You know the procedural aspect of the laws.
Rare combination to have all the courts in one complex.
Yeah, unlike Bombay, there where you have to run down to 10 different courts. So it was a good experience. I would have loved to continue in the practice itself as a lawyer, but due to earning pressures, I have to look for an in-house legal role. So my first job was with an IT company where there was a senior, so I thought I could learn from him. But unfortunately, left in a month's time after I joined. So I was exposed. I was the junior most there, but I was reporting to the CEO, and somehow they never appointed a senior, and it was a scary experience, I would say. Yeah, because to be responsible for handling non-lit profile, the company was thankfully not into litigation,
Okay.
but there was a lot of software contracting and all to be done. So I had to.
Which period was this? Like year wise, if you can put some number of
This
years
was
around
around
it.
2007 to 2009. So in that period, I had to put a lot of efforts into getting to know what non litigation is,
Correct.
what contract drafting is. And thankfully, at that time, there was a forum called as a technology law forum. So I met this gentleman known as Mr. Subramaniam Bhutha. He was at the helm of Tata Group.
Okay.
He used to even advise Mr. Ratan Tata, but very down to earth person. And he had started this venture to conduct free seminars for budding lawyers. He used to get all the industry experts who used to voluntarily come there and give lectures, and that was a great learning experience. And I've carried it with me till this stage of my career. And I always feel that I should do something like that to give back to the
Legal.
students
Correct.
and because it's a great initiative which I've, and so I thought it's worth mentioning about technology law firm. It's still active, and I would like to be a part of it. Then after that, because it was I had no seniors there, I was not sure whether I was doing the right thing, and I wanted to be in a mentored by a seasoned professional. So then I ventured into Reliance gaming business. That was Zapac Digital. That was my first stint with media, so to speak, after IT, and that also gave me a kind of a perspective where my interest lies. So media was quite exciting because there was new challenges every day, there were new things coming up, new things to handle. So it was a very good learning experience when I joined Zapac. After that I moved on to Star India, which was the first big broadcaster I've worked with, and from there it was just a media journey, hardcore into broadcasting. Then Balaji Televisions happened for 3 years, then Z, and now from past 9.5 years, I'm being with Mirchi.
9.5 years. Wow. You're almost on the verge of completing a full decade with Mirchi. Awesome. Awesome. Prashantji, 2 decades of experience in legal industry with Star to Z to Balaji and with Mirchi for 9.5 years. Now, each of this transition that you have undergone, has that made any difference in your dimension to decide on legal stuff or taking a legal decision or judgment for your organizations that you are representing? And these change in roles, did they bring any kind of creative angle to your role? Because it's media then, right? After Star, it's media through and through. So your thoughts on that?
So the change of roles have, of course, shaped my career a lot. At the start of it, it was more of a technical thing. being very good at the technical aspects of the contracting, the licensing business, syndication, production, knowing the nuances of the business, ensuring that the contracts are well made and watertight and we don't let go of anything. Very being very conscious about the drafting negotiations part of it. So starting of the career, right from Star, Balaji, Star was more of the broadcast part of it, and Balaji was more on the production, the real on ground raw production things. So getting directly in touch with the artists, knowing their pain points, what things have to be therefore covered in the contract. It was a very grounding experience, I would say. It exposed me to the realities of television production as well as the movie production business of it. So what all really goes on at the ground level, at the production level, we used to visit the sets, actually see what's happening there. There are many times when we sit in the office and draft contracts and we are divorced from the reality actually. So there are many things which get left, many things which you don't cover in your contracts, or so there are some things which you over cover in your contracts which are not really required. With artists, it's more about the trust, building the relationship, and covering, knowing their concerns, and it gives you a perspective while negotiation what to really fight for and what to let go, what will really not affect your business in the long term. So that was a big learning phase till I joined Mirchi. In Mirchi also, it was first few years it was very technical. I was handling complete non-litigation part of it. There was a very good senior. Was fortunate to work with Mr. Keza. So he was very good with litigation part of it. He was used to handle the entire litigation and government portfolio. And he was kind enough to give me the freedom to take care of the non-litigation part of it, take the call. Even though I was one level down, he used to give me exposure to the management. It was not like that. I will do all the cream work and you on. So it gave me a lot of opportunity to build my understanding of the business. And once he moved on, the management was confident that I can take up his role, though I had never took up litigation till that point of time in corporate. And that was a kind of again a scary kind of thing whether I will be able to manage that or not. But as then when I got into litigation, I found it more interesting than the non-litigation part of it, surprisingly. Then it was more of a strategic kind of a shift from a technical to a strategic. Then I was managing the teams. So there were different aspects of how to interact with the team, how to encourage them. I had a lot of tough bosses in my earlier career.
That's a good thing. That's a good
It's a thing in a way. So I tried not to be like that to my team to the extent I could. At the same time, giving them liberty to take calls, giving them responsibility. Because as they say, with great powers comes great responsibility. So it kind of makes even the junior people in your team take up the kind of responsibility and stand up for themselves and for the team. And so the main shift was from the technical aspect to the focusing more on the commercial aspect and designing the strategy for the management, advising them, and being a trusted partner to the management.
Now, early in your career, working on programming, syndication, and licensing contracts, you must have seen situation getting unfolded. So, how do you think your biggest misconceptions got corrected, and especially in the segments of disputes revolving around content creation?
So earlier, the idea was that if you have a watertight contract, then you're secure. If you have all the necessary clauses in the agreement, then there is not going to be any dispute. But that is not the reality. What happens in the real sense is what your commercial team has negotiated, what they want to actually license out, and what they are actually giving it under the contract. So if those things are not aligned, then the disputes are bound to happen. Okay, your rights management is the most important part of your content life. You have to understand the various technologies through which your content is going to be exploited, what technologies your licensee is going to. And so there are two aspects of licensing. One is where you're acquiring the content, and once when you're syndicating it or monetizing it. So at the time of acquisition, you have to be as broad as possible. You have to take as much right as possible from the future monetization part. You have to be able to monetize it yourself. You have to be able to publicize it. You have to be able to promote it. There are a lot of restrictions which come in the content acquisitions, which you have to be very careful of. And then when you're syndicating it, you have to be as narrow as possible. For that, having the knowledge of what various kind of rights you can slice and dice your content into is very important, because that plays a big part on how you, what you can say, architect your contract, how you make the definitions so that they are less and less ambiguous. The more open you keep the definitions in your licensing contract, the more they are prone to dispute. The licensee can tomorrow come out and say, ah, this was permitted in the contract, so we did it. And then you don't have anything to defend because your definitions are not clear. So that's the important part of it, being very specific, both while acquiring the content and giving it out. Understanding the technology and how it pans out, and your territorial restriction, your holdbacks, and what is permitted for yourself. Otherwise, sometimes in license, exclusive licensing deal, you don't keep any cover for yours, and then you're stuck. Then your own team cannot do what they want to do, even in the territory which you have not given out.
Oh,
So all these things are become very crucial. And
very interesting. On these structuring, then I believe role of you or role of any legal advisor who is operating in the company becomes very critical, right? You must be part of all these discussions and arrangements and managing the whole planning of multiple directions in which the content is going to get exploited for the commercial gains. So how often you get to play the active role in these conversations? Do you bring strategies, or you confirm the strategies that the commercial team is putting in, or you both end up finding out some third strategy?
what I've observed over the career is that the commercial teams always involve the legal teams at the later part of, just for the purpose of contracting, which should not be the case actually. There should be a proper alignment between the commercial and legal team right from the start when the negotiations happen. And the legal team should be involved at as soon as possible rather than at the fag end of the deal. That helps to actually structure the contract well, and to understand what your commercial team actually wants to do in a certain kind of. For that, having a conversation and asking the right questions is the key to it. So whenever I get a vague kind of email, I never react to it. I first pick up a call on that person rather than mailing them and trying to understand, "Ki, what do you actually intend to do in this deal?" Because there are many times when your commercial team does not think of certain aspects which can be problematic for them. Right now, when they are doing the negotiation, they might not think of it. So from your experience of the past deal, you have to make them aware that, have you thought of these things? Have you thought of tomorrow if there is a new technology, what are you going to do? So if you're, for example, if you're doing an event and you're not taking the on air rights for the event, you're not taking the broadcasting rights from the artist, then it becomes a problem if you intend to actually shoot the event and put it on air. Sometimes the event teams don't think of it. So you have to put the right questions to them. What are you going to do that can, whether it's going to be short, whether it's going to be put on YouTube. You need different kind of rights for that. So once you know the kind of nature of your event and what is intended to be, whether it's only supposed to be on ground or it is going to be on air, then what kind of music is going to be included in the things, you know. So once you have the visibility of all those things, you can advise them better actually. And sometimes they even don't come to you for contracts for many aspects of it because they think that it's a low value thing. Yeah, I don't need to have a contract for that. अरे 10,000 का था तो मैंने नहीं किया. Those kind of things. But what they don't realize that because you have not done a contract and you have not taken an IP or a copyright, where the 10,000 ka thing or a artist who is sometimes doing voluntarily for some things for you. If you don't put it in writing, tomorrow it can be a huge dispute. If you put it on air and someone just wake up that I have a right for that. You cannot monetize without my, then it becomes a big issue for them. So all these things can be avoided if you have the right kind of conversations and right kind of questions right at the start of the day.
So, specifically on this point, since last 2 days, I'm getting to see an update on Instagram where Durandar's one very famous song pertaining rights have been claimed by the Trimurti Productions. What's your take on that?
I say I don't have the details of the deal. What actually happened?
Let's assume Trimurti is right in claiming that they have not given the rights of their song Hawa Hawa to Durandar production house. If that is, assuming that is true, that Durandar production house or producers did not take rights from Trimurti films. In this scenario, what are the Trimurti productions or business producers' rights on that Hawa Hawa song?
Then they don't have the producers don't actually have that right. Assuming those being the circumstances, then the only option left is to negotiate a kind of deal with the owners of the song, saying that it was inadvertently used or it was used for a. And that's what typically happens, as I said. Ki sometimes the creative people are so enthusiastic about the creating the content. They want to have an factor to the content, and that's why they want say 5 seconds or 10 seconds kind of a clip without actually thinking that I need to take a proper license for this, because they think that it's kind of a de minimis. They have sometimes heard somewhere a term called de minimis, and that's an exception.
What is that term? What can you break it down?
This is basically using a clip or a song for say 5 seconds, 10 seconds. That's a big misconception actually. If I'm using it for that short period of time, then I don't need a license for it. It's somehow it has creeped in the media and entertainment sector, and it's becoming a big kind of an issue. So the test to that is that how impactful that 5 to 10 seconds of that clip is to your scene. If it's very important, adding value to that scene, then of course the owner has a right to it. But if I'm having a conversation with you and there's some song playing in the background for say 5 seconds, 10 seconds, but it's not adding any value to the conversation. It's not suggestive or on the topical, what I could say. If we are having what you can say a conversation on a legal aspect, and there is some song playing which has some connotations to it, then it adds value to that scene, and it's an intentional addition.
So we discussing also is permitted or not?
Yeah, of course.
Great.
Of course, if there is nothing playing in the
Yeah,
background,
then it's okay.
which is so the thing is, it's not always a rule of thumb that if I am playing it for a short time, then I don't need rights for it. That might have been the case. I don't know, but then the only option left is to say that it was a mistake, and what can we do to compensate for it, or there are other commercial negotiations. There can be a revenue share or something.
As per as my knowledge is concerned, Trimurtis have moved for a litigation for claiming damages from Aditya Dar's production house. And interesting battle to see. Third battle, the third part of Dhurandhar will be in High Court then, in litigation scenario. Another take on this D minus you said, right? De minimis. So another thing on this de minimis concept, a lot of content creators, especially those who are doing geopolitical case studies, they end up showing first channels some clips where Palki is talking, then ANI channels some clips have been talked. I know about some of the content creators getting notices from these good news channels, and we advise to some of the content creators also. So if you were to advise them, how would you guide them if they have already used content, what they should do, and if they are about to release a content which has ANI clip, for example, or Republic Channels clip, for example, what kind of disclaimer, disclosure, or precaution they should have?
It depends on whether they are monetizing the content or not.
Let's assume they're doing it because most of them are actually
Yeah,
monetized.
if that the intent, then it's imperative that they take a proper license, sync license from the content owner, whoever it might be the,
Any news channel or anything.
or it might be a. So it's very important to take a license first. If they have not taken it, then they should hope that it's not get noticed by the copyright owner. But if it does get and they get a notice, there is no point in actually defending it because the proof is out there on air. So the only option left is to negotiate with the copyright owners to share a percentage of whatever you have earned from it, or a lump sum amount, depending on the kind of usage.
So what we understood in recent times, whenever any um, social media influencer on Instagram or YouTube, they were putting all this content with some micro clippings of 3 seconds, 5 seconds, somewhere some politician is coming or some attack is happening, and all that was captured on the channel. And unfortunately, they got notices, then they got calls with demands, then some sort of exorbitant amounts were given as a condition. And when they did not budge on that, then the content owners, the original content owners, went to YouTube with a request to strike off that content. And also, it is understood that when such non permitted use of content is done, sometimes the earnings of that video gets passed on to the original content creator by YouTube. Is this true?
Whitelisting.
Yeah.
It's called whitelisting. Yes, that can be done, of course. If you don't want to get on the wrong side of the copyright owner, you can do that. So you can use that content and then allow the actual copyright owner to earn from it. Or you can pre-inform that copyright owner that, okay, I'm using this thing, but I'm whitelisting the content, and you can earn all the revenues. My intent is only to show that particular news on my channel. So that's another arrangement which can be done.
So, Prashantji, many content disputes are effectively resolved before escalations, provided those situations are tackled and handled by the verticals of the businesses that are involved, as well as legal team stepping in. So, in your experience, to win such situations or get effective control over them, what is crucial? Contract drafting, negotiation leverages, or relationship management?
Once the dispute arises, after once the dispute arises, the most important thing is dialogue, because contracts are just paper, but it's more about the relationship. Many times the parties want to resolve things, but there are different aspects like misconceptions or misalignment or ego issues, which can be 90% of the time resolved just by a honest dialogue between the parties. So it's important for even the legal person to talk with the commercial team or whoever is on the business side of it to understand the nature of disputes. What are the avenues that it can be solved outside the court or before it lands into the court? Is there any, for example, if there is a default, there are many times when I've seen that a person is genuinely not able to pay because of some family issues or some business issue. It might be temporary. So you don't have to, every time, you can just send a notice to have the matter on record, but you don't have to pursue it aggressively if you know that the case is genuine. And that can be only known to your business people because they are on ground in touch with the party. So you can advise them to talk to them if they are ready to give you a deferred payment plan, if we offer some discount and get those things recovered. And many times things get resolved by this method. Because if you go into litigation, you might end up spending more than what are you trying to get benefit out of it or getting recovered. So it's always good to have these alternate things access first, and then if there is no other alternative left, then you go into the disputes. So no matter how good you draft the contract, disputes are bound to be there if there is a misalignment at the start.
Dialogue is the way forward with taking all good legal precautions in place. So, putting the dispute or the issue on record and then not jumping to the court litigation immediately, having a fair opportunities for both the parties to come down and explore mutual, arrangement or agreement. Very well said. I think that's the best way to forward. Courts are asking us to do that. If you file any suit in,
Now pre-mediation is becoming mandatory.
so commercial disputes cannot be taken into argument state immediately. You have to explore mediation.
And it helps in many cases when the parties sit across and tell each other's concerns and they understand each other's concern and they can avoid that costly litigations. I think many businesses are opting for it.
Absolutely, absolutely. Great. Uh, Now we'll focus more on radio as an industry because you are associate with radio channel, Mirchi channel for almost 10 years. Uh, we all are experiencing this internet, Instagram, social media, all of that. Where is the radio industry in all of this now? And what's the future like for radio industry? Strictly from your personal views.
See, radio has been always a favorite of many people because, as I said, it leads to music discovery. That's the first place where it has a surprise element. When you're driving, you don't get to, you don't need to choose a song, and of course, you don't want to choose a song. Sometimes you want a song to be discovered by accident, and then you listen to that song. If it clicks with you, you go to a streaming platform and you look for those things. And so it's a very good platform for discovery of new music. It gives a big platform for new artists, especially the traditional artists, the local artists. It has a very local connect. The RJs connect nicely with the local audiences, mostly into two tier, three tier cities also. The RJs are like celebrities. Yeah. Yeah. So it's a very good medium and it should survive. And I personally like radio. I'm quite passionate about music. I like radio as a medium. But unfortunately, what has happened is the receiving equipments are disappearing from you. Now people don't consume radio much on the traditional radio set. It's limited to drive time. So the receiving equipments have become limited and that it's limiting the listenership. So the only way to expand it is by way of including it in the smartphone. So we have been lobbying with the government a lot to mandate radio reception in the smartphone because though that's where the our new audience lies. The most of the teens are now on smartphone, and that's the only medium where they can consume radio apart from the drive time. And right now, it is available only in the feature phones, which only is consumed in second, two tier, three tier cities, but not much in metros. A lot of listenership this. So I think once we expand that, then will see a quite a big growth in the radio industry. And also, we are running for certain reforms in the radio sector. TRA has come up with very good recommendations in their recommendations of 2023. They have given it to MIB for implementation, and we are just awaiting. We are hopeful that those will be implemented very soon. Those are relating to the license fees being rationalized and news and sports content being allowed to. Right now, as we speak, we as a medium are not allowed to broadcast news content and sports content, which is a big handicap, I would say.
Really? Like, so correct me if I'm wrong. If I get to know the score of an IPL match that Mumbai Indians is playing versus CSK, is it allowed or not allowed then?
A ball by ball commentary is not allowed
Oh,
unless we take rights specifically from it from the official broadcasters or something.
okay.
Then it's sometimes allowed, but otherwise, as a rule, we are not supposed to do a ball by ball commentary and nor a live news update on anyone. We can sometimes give what you can say a breaking incident kind of a thing which is happening locally, but not a very news content in that strict sense.
So like an update is fine, like deferred update, like
Yeah, deferred update is fine
India,
in
Mumbai Indians finish the match with so and so score, that kind of update, or after 10 hours, 15 hours, they are just giving a
or a newsworthy content like Sachin has scored a century, that kind of thing, but not as it happens.
not the live commentary part.
Yeah. So that makes the radio sector heavily dependent on music, and the music royalty cost skyrocketing. So biggest payout expense, what I could say. That of course affects the profitability in some sense. So I'm quite hopeful about the sector because now even the digital radio reforms are on the cards. We are hopeful that those will be rolled out soon. There's a lot of clarity yet to be coming in terms of the technology which would be used for that, the infrastructure costs and all. There are a lot of aspects.
What will change? What would change that from current one? What do you call the current radio infrastructure then? If we have
Currently, it's analog, digital, analog terrestrial.
analog terrestrial.
Yeah. So once the digital technology comes in, the sound quality will improve. There will be options for more channels available for the existing broadcaster. Now we have to see whether it comes at a additional price or at the same price. That again depends on the policy initiative. So there is a lot of clarity yet to be coming in, but I'm sure once that clarity comes in and digital radio becomes a feasible option for the existing broadcasters, it will revolutionize the space. I guess.
So Prashantji, the favorite hot topic of everyone now, artificial intelligence, and legal industry is also not, staying away from it. We are also seeing courts, lawyers, law firms, companies, legal teams, all are getting some or the other usage of AI in their routine. In our earlier conversation, you also indicated that you have taken a dedicated course of MIT Institute from USA for understanding more on AI. Can you throw some light on your learning from that course? And also, what is it that we should be mindful about now with the AI usage? How we as a lawyer or legal community member, we go about adopting AI with responsibility so that our documents, our actions, our outputs that we are giving to the end user is protected through and through.
So adopting AI now is not remain an option anymore. You have to adopt to that technology, and it's a very good, useful technology, I would say. So just to get a learning of how it works, what are the basics of AI, what is agentic AI. So that was my purpose of behind doing that course. Because even though I'm not a very technically sound kind of a person, I don't have any programming background, anything. So I won't understand the mechanics of it, but I need to know how it works because it will give me an idea to how it can help me in my work, whether I should recommend to my management to whether is it worth recommending it, whether it actually helps reduce the time that we spend on documents, how useful is it, how much I can do on myself with my limited knowledge of AI. And having a business knowledge also matters because tomorrow if I have to get into some contract with an AI vendor or if I'm buying an enterprise level AI product, then the first thing, as I earlier mentioned, was to ask the right questions. If I don't know how the AI works or what are the nuances of AI, I won't be able to cover that in my contracting. So that was my basic purpose, to understand how these things are, what are LLMs, what are agents, how is one model different from other, which is the best one to adopt, and how the pricing works basically. So when I did that course, I was introduced to tokens, how the LLMs actually are getting priced. Right now, everything is free, so everyone is happy. So they are getting people used to these kind of things using the AI, and once they are used to it, they will start the subscriptions, of course, and they will start increasing the subscriptions also. So it is very important to know how these tokens work, what is the pricing, which are the best, cheapest options available. There are various tokenization websites, calculators, which you can estimate the kind of typical queries which you have. You can put it in the token calculators and come up with an estimate. So it kind of gives you a perspective ki which tool is better suited to your business, which is not. So even though you might not know the programming aspect of it, the knowing how it works is absolutely essential. And also what I learned in that course is that you actually don't need to learn programming. You can actually create codes just by vibe coding, as they say. Just by putting the right prompts, you get the entire Python code, and you can just copy paste it in the right environment, and you can make. I made a website of my own. Of course, there was no backend. It was not a working website, but it was quite fun, and I'm quite excited about that technology. I'm as excited as a child to know how it works and how I can play with it. So it also gave me a perspective why the hallucinations and everything is happening right now, which is the biggest talk of the town. The courts are very concerned about it. So it's basically because people are asking wrong questions to the wrong model. Yeah, generative AI is not like search engines who will not give you results if they are not there on the internet. They are built in a certain way to predict. So if you're asking it for a case law, which is not there, it will come up with something from its learning.
Wow. That's very risky for us, but
So asking it to the right model is important. So there are many models which have come up like RAG or CAG, which is a retrieval augmented generation, or cache augmented generation, where you feed the model with a specialized data. It's like a general lawyer. If you go to a general lawyer, is not specialized in a particular field. So, for an example, if you ask a question about a maritime law to a real estate lawyer, he might not have the idea of it. What we are trained as lawyers during our course is some representative laws, how to read the law. We are not taught each and every law that exists. We are just equipped to read those proper law. So LLMs are like that. They are trained on large data sets which are general in nature. If it's available there out there, it will be able to answer. If it's not there, it will generate something. So it's your responsibility to verify whether it's serving your purpose. There are ways of asking for the links of the case laws which throwing it at you. You can go to the links and actually see whether they are existing or not. Maybe someone has not taken that efforts to go and actually verify. So all these things are there when you fine tune your softwares and customize it for your particular purpose. Then they are actually more helpful than just using a general LLM for your legal work.
follow. Very true. I think in my limited experience of using AI, it started with ChatGPT, as we all, most of us begin with. But soon Gemini, Perplexity, Claude, all of them are there, and I end up using some of them. Then recently we came across emergent AI, which is to create many things that you as a layman would not be imagining to do, website, apps, things like that. Again, but same problem that you mentioned. You have created your website, but backend, who's going to actually activate it for it to go live? But the design is ready, the layout is ready, functionality is quite there. So demo is ready. The activation part remains with the technical expert to come in. But very interesting times. We are seeing things getting finished in surprisingly less amount of period. In my last conversation with Mr. Zamir Nathani, I think he's your ex-colleague also. We were discussing about one statement made by Lehman Brothers official, Lehman Brothers, or one of the big banks from USA, that the time it used to take earlier to do a paperwork for IPO listing used to be 3 months, and team of around 20 or 30 lawyers they used to need. Now the time is reduced to 7 days with two people with the AI. Imagine the time, the utilization and dependency of on individuals. So with the good adoption and faster work turnaround time, we are also looking at need of limited legal professionals that are going to be needed, and it's going to reduce, the need will be reducing. So while we see jobs are not going to be that easy to get in at entry level, but the positive side that I see is all these newcomers are end up going to they will end up starting their own practices also very early. And That can be also a very different pool of offering they're going to bring in market, and there'll be more service providers than more retained attorneys with law firms or legal managers with the companies at the entry level to go about.
So adoption is not an option, as I said. We have to adopt, and but I don't think there is a need to be scared of the technology, or will it take my job or something. It's about learning how to use it and keep on experimenting with it. Like in my daily work, I experiment with custom GPTs. I use my existing SOPs for the thing, for the department. I create a custom GPT out of it, and then it becomes easier for any new person to interact with it in plain, simple conversational language, and it gives you exact output because you have given it a reference. So that is what we call it as cache augmented generation, or CAT, I think. And that has been possible because the even the LLMs are improving. Earlier, the context window used to be of a limited token. Now it has become so big that you can attach a lot of documents. So a RAG model may not be very relevant right now because it is very expensive. A fine tuning which retrains the model on your legal database or kind of it, that is a very expensive thing. So CAG is a very inexpensive and ready to use kind of thing option which has been available, and I think people should use it. You can just upload the document, and then your search is limited to that document. You get very pointed answers. If it's not there, you can set the rules that you return output to me that it's not there. Don't go beyond. You can set proper guardrails and ensure that the your AI does not hallucinate. So all these things can be taken off.
What is RAG? You said CAG, I understood. RAG, RAG.
RAG is basically retrieval augmented documentation. So you to your existing model, you add another model which has an embedding kind of a model. Then there is a vector database which converts the output into number, and then it searches. Your query is related to the input which you give. The whatever the database you have built, like you can load all your the entire content library. For a law firm, it might be a list of precedents or say the cases which they have worked on as a reference. So your query is not like answered in a very general way. It is answered with the help of the database which you have fed in it, and you get a answer which is customized to your requirements. So it's a very helpful technology. But as I said, the new thing you can, if you want a quick answer, you don't want to go take all that efforts to load a separate kind of a model. You can upload the documents right now in your context window, and then you get a pointed answer. How you explore the technology, and it's also important to make the use of the settings of the software. There are a lot of settings in your open LLMs also, which where you can limit the exposure of your confidential document. They are not used for general training purposes.
But does it come with as an option with free subscriptions or?
It is there with the free subscription
Wow,
also. It's just a toggle button which says that don't use my documents for AI training purpose. So it doesn't go into the public domain.
okay,
It remains confidential. So all those things have to be taken care while you are using the AI.
interesting. You certainly did lot of work, study, and you have understood also very critical nuances of artificial intelligence, Prasantji. Because the way you have explained and broken down all the things, it's very difficult for a lawyer to see other lawyer doing it. So I'm very impressed with the way you have shared your perspective on artificial intelligence. I think I'm going to come back to you again on many of the suggestions that we will require on artificial intelligence. Last question, Prashantji. If you had to define legal philosophy of yours in one sentence, what is the role of lawyer in a content-driven business? How would you describe?
In a content driven business, it has to be a business partner and not just a lawyer. You have to understand what are the avenues available for your maximum monetization of your content and be able to be a business advisor, it is as important as being a legal advisor, because legal has its own limitation. But how it contributes to the revenue growth, uh, how you align your business team with ground reality, and the licensure, what all things you can do with the content, there is no limitation. Sometimes the syndication teams are not aware of it. So once you have the alignment with your commercial team, that's when you bring the maximum benefit to your organization, and that's when you feel like you have done something, and you are a part of not only protecting the organization but having a contribution to the leadership as well.
Perfect. Thank you so much, Prashantji, for your unfiltered sharing and putting all the important aspects of your legal journey, plus the industry, plus what is good for the seniors to juniors from the AI angle to managing the whole ecosystem pertaining situations. Thank you so much for this sharing.
Thank you.
Thank you. So, viewers, this was an excellent brand new episode of Due Diligence with Rahul with Mr. Prashant Ramdas, legal head and vice president of Mirchi, a radio channel which is leading in India and world renowned. And it was an amazing episode in which we got to learn so much on media, entertainment industry pertaining elements, right from his experience from Star, Balaji, Z, and Radio Mirchi. We are really thankful for Mr. Prashantji's sharing, and we hope this insight that you got from this episode makes more clear picture for you as to how content industry is adopting AI, taking new steps, moving towards transformation from multiple segments and sectors. Please share this content, like and subscribe, and give your thoughts in the comment section so that we can bring more such guests to our platform, to our show, and create more useful content to understand more on legal insights. Thank you so much.